We now invite a scholar, author, and practitioner whose career embodies the delicate balance between legal reasoning and human empathy. Dr. Aditya Sondhi is a senior advocate practicing before the Supreme Court of India. He has served as Additional Advocate General for the state of Karnataka from April 2016 to April 2018 and has been appointed amicus curiae in several matters of public importance. He has taught constitutional law, arbitration, and professional ethics at the National Law School of India University, from which he graduated in 1998. He has also taught a specially curated credit course on courts and national security, and has contributed to the Oxford Handbook on the Indian Constitution. He was invited to appear before the Parliamentary Standing Committee on Home Affairs introduced in connection with criminal law reform in 2023. He has appeared pro bono in several death penalty cases before the Supreme Court of India. He has instituted the Bina Sondhi Scholarship for LLM Human Rights, Conflict Justice at SOAS University in memory of his late mother. He hosts a podcast called A Podcast for Conversations Around Caste. We now welcome Dr. Aditya Sondhi to the stage.
வணக்கம். நான் இனி இங்கிலீஷ்ல பேசுறேன். Thank you to friends at Ambedkar for this invitation, and it's an honor to follow Professor Kumar, whose work I admire and respect. And I acknowledge my friend Philip Wallen, OAM, in the audience. I'm sure many of you know him as a distinguished Australian, but Phil, will you please stand up? Phil's presence here is no coincidence. He's a dear friend of mine, but his work and life actually fit the theme of humanism better than any of us. We just do the talking, but he has dedicated most of his life to animal welfare, the ethical treatment of animals, kindness, compassion, and therefore perhaps he should have been on stage speaking about compassion this afternoon. I'm going to speak to you about the treatment of Dr. Ambedkar in judgments of the Supreme Court of India from an authenticity perspective. It's a complex topic for multiple reasons. One is, of course, what is the definition of authentic theoretically? And I've approached it merely from the perspective of what is the original voice that one can attribute to Dr. Ambedkar, and how fairly has it been accommodated in judgments of the Supreme Court. The other challenge, of course, is the volume. Even ChatGPT couldn't tell me how many times Dr. Ambedkar has been cited in judgments of the Supreme Court. And that's to his credit, because he has been cited far more than any other scholar, political leader, or even Gandhi for that matter. But it is still incumbent on us to audit how accurately and how holistically his ideology stands reflected in the jurisprudence of the Supreme Court over the past 75 years or so. Therefore, for one to address this question, we need to first see what is the core voice of Ambedkar. a difficult proposition to begin with, but that has to be laid out before you go into the latter part of examining how the Supreme Court has invoked his messages. You know, the conversation has been centered around caste and but naturally around reservation. But Dr. Ambedkar's ideals went far beyond that. Uh, I find it reductionist to equate Dr. Ambedkar with reservation alone, because his idea of reservation was really one of the spirit of equality. It was not reservation. There's a certain stigma or value judgment that comes with the reservation, but when he spoke of the upliftment of the scheduled castes, of the Adivasis, the Aboriginals of India, if you will, he approached it from a spirit of constitutional equality, and to his mind, treating unequals equally in itself was discriminatory. So, came with this his emphasis on protection of minorities. He believed that minority rights are absolute. Again, difficult to fit into a constitutional realm, but that was his perspective. He was big on gender protection and gender equality. And of course, he firmly believed that liberty, equality, and fraternity went together and made up that golden triangle in the Constitution. When it came to fraternity, and this was really Baba Saheb's take on social democracy, right? The idea of giving a vote to an individual was politically correct, was political equality, political democracy, but it's not social democracy. Social democracy is when all voices are respected, measured, calibrated, and then accommodated within the geopolitics of the time. I think he would have been thrilled to see the acknowledgement of the First Peoples and the elders that we saw throughout this morning, and in fact everywhere I go in Australia. And on fraternity, he drew his theory from the Buddha, in fact. As you heard Professor Varmakumar say, he converted to Buddhism, and as his biographers point out, he said that though he was born a Hindu, he would not want to die. But he switched to Buddhism again on a moral premise. It was not opting from one religion to another, and therefore his voice was steeped in morality. He could have chosen Christianity, he could have chosen Islam. He seriously considered Sikhism because he found Guru Nanak's views close to his heart. But ultimately, he found that Buddhism presented a certain moral code that resonated with him the closest. And on fraternity, the point I'm making here is that his religious beliefs, his moral beliefs, and his constitutional beliefs actually align. That is the voice of Ambedkar. On fraternity, he said, I have derived these three concepts, liberty, equality, and fraternity, from the teachings of my master, the Buddha. He said this at a Constituent Assembly debate. And he said, I have to therefore do the work of conversion. So, for you to achieve this constitutional ideal of fraternity in his mind, ultimately, you needed to demolish the inbuilt inequities in Hinduism, that is caste. He, of course, believed that the constitution was sacrosanct at one level, and while it could be amended, while making amendment, there had to be sufficient safeguards, checks, and balances so as to preserve the core of the constitution, if you will. And of course, his greatest contribution, I think, as I said, goes beyond just doctrines of reservation and upliftment, but his greatest contribution was in the realm of constitutional morality. And this is a much understood and misunderstood theorem, and I don't have time to go into it. But suffice it to say that because of Baba Saheb's lived experience, his engagement with philosophy, with economics, with the law, with politics, with constitution drafting, and interaction with people across the globe, brought him to the conclusion that the constitution itself would probably always be inadequate. as a document. But if it was understood and applied in the element of constitutional morality, then it had a fair chance at succeeding. And at the heart of that idea of morality was looking out for the underdog. That in any situation of legal or judicial interpretation, as the lawyers here will confirm, there is always an underdog in the fight. Right? That underdog could be a citizen, it could be a migrant, it could be a minority, it could be a woman, it could be a queer person, it could be a Dalit, it could be somebody with physical disability, or in some circumstances, the underdog could be a region, or the underdog could be a state. When we speak of center-state relations and federal disputes, many times the underdog is the state, and that list is fairly endless. But the point is that when it comes to interpreting these situations in a constitutional realm, the doctrine of constitutional morality would guide the lawmakers and the law interpreters to keep the underdog in mind. And if you do that, that would be the opposition in power. If you did that, then constitutional morality would be met. And finally, let me say this, that it's also reductionist to equate Baba Saheb's work with just things he said at the Constituent Assembly. His work and his body of work transcend just those Constituent Assembly debates. And he, in fact, was on the record to say that I'm but a hack, right? Most self-effacingly, he said, I'm a hack when it comes to the Constitution. He was disgruntled with the document at some point in 1953. He, in fact, said, I would like to burn it down. When he said that, people have picked it up and said, oh, look, Dr. Ambedkar was not a believer in the Constitution. That's not true. His frustration came from the fact that he still had to accommodate so many power centers that his ultimate objective, which was to bring in the Hindu code and to revamp Hinduism and annihilate caste, remained a pipe dream. So, this voice, this conflict, this nuance of Dr. Ambedkar finds reference sometimes adequately, sometimes inadequately, sometimes not at all in the Supreme Court of India. And it's not possible for me in the short, Anna gave me the instruction to wrap up strictly in 15 minutes, which I have 4 more minutes, thank you. Though those are scarcely enough to cover what I want to say. But the point is, in trying to locate this voice of Dr. Ambedkar in judgments of the Supreme Court, let me first quickly tell you, and I'm happy to report to you, that in many key aspects of lawmaking and laying down of constitutional principles, the Supreme Court has been guided and led by what Dr. Ambedkar has said or written. That's, for me, that's critically important, right? That's the first part. And here, every dimension of the law, when it comes to the concept of federalism, in Shamsher Singh, the Supreme Court said that, we're not presidential, we're parliamentary, we were both unitary as well as federal in structure, and that neither did we lean in favor of giving wide powers to the union and maintain the preserve of the federal characters of the states. This principle was drawn from what Dr. Ambedkar had said on the floor of the House when the Supreme Court had to say that the governor didn't act in their own capacity but was bound by the advice of the Council of Ministers. When it came to the interpretation of Section 6A of the Citizenship Act, which was a result of the Assam Accord, again, the Supreme Court drew on the principle of fraternity that I told you. Of course, when it comes to reservation, and probably that's where the linkage is direct, that everything that Dr. Ambedkar said about the idea of giving communities a look in, as he quoted it, was acknowledged by the Supreme Court leading up to the Indira Sani case, the famous Mandal Commission case, where chapter after verse drew on Baba Saheb's philosophy to say reservation was concomitant of equality. Reservation was not discrimination. Reservation did not fall foul of the promise of equality under the Constitution, but it was in fact a springboard to equality. By correcting generational imbalances that had occurred, this was in fact our moment to reconstruct equality in society. And this list is endless. It's been extended to minority rights when it came to the Aligarh Muslim University's case on a question whether a university established by a statute loses its minority character. Again, to uphold that minority character, the Supreme Court fell back upon Baba Sahib's writings and work. And more recently, when it came to the eradication of pernicious caste practices in prisons. Indian prisons follow obnoxious caste discrimination. You won't believe it. Caste, as the professor said, doesn't escape us at any level, be it temples, educational institutions, at home, and even in prisons. Even in prisons, the most menial tasks of cleaning toilets, etc., were again caste specific, and the Supreme Court drew on Baba Sahib Ambedkar to try and remedy that. But I refer to constitutional morality, and it was in S.R. Bomai's case when the Supreme Court had to deal with the question of the scope of power of the president to impose emergency in a state, and as to whether that was justiciable. The Supreme Court once more fell back on Ambedkar's idea of political morality to say that emergency powers were in fact never really intended to even be used. Ambedkar felt, why would a president need to impose emergency at all? And of course, if they did, then the first thing that they would do is to issue a warning and thereafter act in accordance with the aid and advice of the ministers of the government of the day and the material on record, and not do it whimsically. So all of this and much more has the stamp of Ambedkar on it. Last but not least, falling back, sir, to your point about the judiciary itself, which lacks the diversity that we would like, though it's making steps in that direction. But on the concept of the independence of the judiciary, and this is a lecture in itself, but if I can say it in 2 sentences, we have a system in India where a collegium really operates the process of judicial appointment. And when the Supreme Court was to decide whether the President had the last word or the Chief Justice, it was the concept of collegium was developed to say that the Chief Justice doesn't act in their own capacity because Baba Sahib said that the Chief Justice is not infallible. Of course, that was then built into this concept of a collegium which does not find mention in the Constitution. I don't know what Baba Sahib would have thought of the idea of a collegium, but we'll keep that debate for another time. But let me move on to a slightly grey area when it comes to the application of Dr. Ambedkar's philosophy. And in a more recent judgment of the Supreme Court in Property Owners Association, where a larger constitution bench of the Supreme Court was required to interpret Article 39D, which deals with the treatment of material resources of society and their use for the larger community, the court was required to decide whether this word material resources applied to all private property or not. And by a majority judgment, the Supreme Court held that private property was excluded, and unless there was scarcity and a great community need, this could not have included private property. We'll keep that sort of socialist constitutional debate apart for a moment, but why this judgment is most interesting for me is that the 2 schools of thought, that is the majority view and the minority view, saw Dr. Ambedkar's philosophy completely different. The majority quoted Dr. Ambedkar to say that he was of the view that the Indian Constitution only has an ideal of economic democracy but does not prescribe any one socialistic or other economic model to be followed. And therefore, he was quoted to justify the need to keep private property outside 39. But equally, the minority view, Justice Nagaratna's view, differed squarely with the majority not only on the interpretation of the provision, which is a separate matter, but on the reliance on Dr. Ambedkar's thoughts. And she says that speeches of Dr. Ambedkar in the Constituent Assembly evince that while the economic philosophy adopted by the government may swiftly pass from one generation to the other, the ideal of economic democracy finds firm place within the Constitution. So to her mind, yes, there was fluidity left with governments, but there was a certain ideal. And to me, this case is symptomatic of how Dr. Ambedkar can be viewed from different lenses by the court, but ultimately, the test must be one that returns to his core voice with which I began, which is what you're doing constitutionally moral? If your interpretation is furthering the spirit of the Constitution, the protection of the underdog, the upliftment of that invisible Indian, then your interpretation is in keeping with his ideals. If not, you're possibly paying lip service to him. And I think this dilemma will remain because there are going to be cases galore where Dr. Ambedkar is going to continue to be referenced, interpreted, and debated over. But I must, before I conclude, because I know the time is ticking, refer also to certain silences in the judgments of the Indian Supreme Court when it comes to Dr. Ambedkar. And the most interesting one to my mind was the judgment in Reverend Stanislaw's case, which dealt with the validity of a conversion law or the practice of what we loosely call an anti-conversion law in India. And in the states of Madhya Pradesh and Orissa, there were these anti-conversion laws introduced that penalized the conversion of people from one religion to another. Of course, the trigger for that was what one called the missionary movement to try and convert Hindus and others out of the fold into Christianity. And the Supreme Court upheld that law, holding that Article 25, to which you referred, sir, gives the right to propagate one's religion, but does not give the right to one to convert one to their own religion. Now, this is a debatable theory in itself, especially in India right now, because over the last few years, many states have come up with their own versions and more draconian versions of conversion laws. But what strikes me as most interesting is that a judgment that was deciding this core question of conversion in Article 25 makes no reference to Dr. Ambedkar. A man who said, I convert to Buddhism because I do not want to die a Hindu. And I encourage, in fact, if anything, Dr. Ambedkar could have been found violating these enactments. That's the great irony and paradox of our times. But a judgment like this, which goes to the heart of Dr. Ambedkar's philosophy of equity, of morality, and a better India, is silent when it comes to Dr. Ambedkar. And therefore, as I'm trying to demonstrate, friends, Dr. Ambedkar's legacy is one that transcends debates. It's one that finds itself fitting into some crucial elements of our constitutional law, but at the same time, sometimes conveniently or otherwise, is either left out or is amorphously understood. And I believe now, in the times that we are, when the debate is raging even further, there are greater questions of discrimination, greater questions of citizens' rights, individual rights, government power, etc., being brought to the courts. I believe Dr. Ambedkar's voice needs to be understood with authenticity. If we don't get that right, the question of application really will take us nowhere. I did want to also talk about the application of Dr. Ambedkar in foreign judgments. You'll be happy to know that many judgments, Kenya, Bangladesh, Pakistan, and others, have referenced proudly his contribution to constitutional law, but we don't have time enough for that. Finally, I'll only say that I was reading an interesting paper by Professor Rohit Dey who traces the life of Dr. Ambedkar as a lawyer, as a practicing lawyer, which was not a very long career. He moved quickly into bigger and better things. But he had argued a case before the Supreme Court in 1951 for the Maharaja of Patiala, I think, where he argued this idea of the spirit of the Constitution, right? And in that case, that argument was rejected. But it has found itself being applied in many other ways, and Professor Day argues that the idea of the basic structure of the Indian Constitution, which insulates the Constitution from any amendment which is not in keeping with the basic ethos of the Indian Constitution, is something that can be related back to what Dr. Ambedkar argued as being the spirit of the Constitution. I don't know if Dr. Ambedkar was thinking of that, but knowing him, he was always thinking far ahead of all his compatriots and citizens. And therefore, friends, there are layers and layers to the understanding of Dr. Ambedkar's legacy just directly in the jurisprudence of the courts. And I'm thankful that I got this opportunity to try and develop this. Thank you.